Hey guys, Adam here with Crushendo, and today we're talking the NextGen Bar Exam, which, if you haven't heard yet, it's coming down the pipe from the NCBE. In 2026, it's going to be a substantially different exam than what is currently offered by the NCBE. And if you don't know what the NCBE is, that's the company, the National Commissioner of Bar Examiners, and they create and administer the Uniform Bar Exam, which includes three component parts. You have the Multi-State Bar Exam, or MBE, the MEE, which is the essay part, and the MPT, a performance test part. So all of those parts of the exam are going to be going away. Now, when are they going away exactly? That remains to be answered because the NCBE will be maintaining both the Uniform Bar Exam for a period of time, it sounds like, and the NextGen Bar Exam when they release it in 2026, as states decide when and how they want to transition to the new exam. I recently attended a webcast. Over 200 people attended, mostly folks like me from bar prep companies and from law schools across the country, trying to understand what's going on. And the NCBE seems to be doing a great job. Really appreciate them. They've shared with us the webcast video, and I'm gonna play that now.
Greetings, and welcome to this program on the content of the NextGen Bar Exam. Thank you for joining us. I am Marilyn Wellington, the Chief Strategy and Operations Officer for the National Conference of Bar Examiners. We are pleased to have this opportunity to share critical and timely information with you as we move forward towards this next evolution of the bar exam. Today, you will hear from two key people leading the development of content for the NextGen exam, Beth Donahue and John Lee. Beth is the Senior Assessment Design Specialist for the National Conference of Bar Examiners, focusing her work in this role on the NextGen Bar Exam. She recently returned to the National Conference after working in curriculum development and online assessment management at UNT Dallas College of Law and at a variety of legal education and bar preparation vendors. Prior to this, Beth worked in the National Conference of Bar Examiners testing department as a test editor and then as program manager for the multi-state bar exam. We are thrilled to have her back at the National Conference of Bar Examiners. Beth graduated with high honors from Chicago-Kent College of Law and clerked for a federal district court judge in the Northern District of Indiana. John Lee is an associate professor of law at the University of Oklahoma College of Law, where he teaches evidence, professional responsibility, and intellectual property. Prior to his position in Oklahoma, John served as a professor of practice and assistant dean at the University of Minnesota Law School, and spent several years at the University of North Carolina School of Law as a clinical associate professor and assistant dean for academic excellence. John has received several awards for teaching excellence and outstanding service. He is also a frequent speaker on law school academic success and integrating experiential learning and practical skills training into law school curriculum. His longstanding involvement in the development of the NextGen exam includes service on the National Conference of Bar Examiners Content Scope Committee, which was charged with identifying and defining testing parameters for the next generation of the bar exam. Beth and John will provide you with important in-depth information on the development of content of the NextGen Bar Exam, after which we will look forward to your questions. Given time constraints, we won't likely get to all of your questions, but we will get responses out for those questions that we don't get to following this program. Thank you again for joining us today.
Welcome everyone to our webcast on content NextGen Bar Exam. I'm Beth Donahue. I work at NCBE. For the last year and a half, I have worked exclusively on the NextGen Bar Exam, and especially specifically on the content of the NextGen exam. Next slide. I'll start today by talking about the operational approach that we have taken at NCBE towards defining the test content for the new exam. Then I'll turn it over to John Lee to give you an academics perspective. John has been involved in a couple of different ways in the next gen design and development and in prototyping, and he'll give you a sneak peek at a few different question types that we're considering for the new exam. Then I'll talk about pilot testing of those new question types and the process we'll go through to make sure those question types work for all examinees. At the end, then we will take some of your questions and make sure that we follow up with those that we don't get to. Slide. So beginning with an operational perspective of how we went about defining test content. Slide. As many of you know, the NCBE had a 3-year testing task force that studied the future of the bar exam. Part of that testing task force's work was conducting a lengthy practice analysis of what newly licensed lawyers do in the real world in practice. The testing task force's work culminated in a series of formal reports that can be found on NextGen's website. There were 5 main objectives that came out of that work. First, the NextGen exam should test less broadly and deeply within the subject areas that are covered on the exam. So in other words, less memorization of legal doctrine. Second, there should be a greater emphasis on lawyering skills and a broader number of lawyering skills tested. Fairness and accessibility should continue to be ensured for all examinees. And for UBE jurisdictions, score portability should be maintained, and of course, the exam should remain affordable. Slide. The testing task force also identified 8 foundational concepts and principles or content areas where examinees should have some knowledge, and 7 foundational skills. These areas of knowledge on the left-hand side should be familiar to folks who already know a bit about the current bar exam. 7 of those subject areas are tested on the multi-state bar exam and on the multi-state essay exam, and business associations is tested on the multi-state essay exam. On the skills side, there are a number of new skills that were identified for assessment on NextGen. Legal research, client counseling and advising, negotiation and dispute resolution, and client relationship and management are all relatively new to NCBE, although many folks have pointed out that aspects of legal research have been tested on the multi-state performance test in addition to the writing prompt. Slide. To drill down deeper into those 7 skills areas and the 8 content areas to better define what specifically should be covered on NextGen, we put together a content scope committee last year. This was a 21-member committee, a diverse group from across the country, relatively evenly split between more doctrinal faculty and practitioners and clinical faculty, and they came from 16 jurisdictions and 15 law schools. Next slide. To think about which topics should be covered within the subject areas, we talked about which topics were important to the beginning practice of law and important enough to be on the bar exam. We defined importance with 3 factors: frequency, universality, and risk. Frequency, meaning how often would this particular topic come up for an entry-level practitioner. Universality, meaning how common is this topic across multiple areas of specialty. And finally, risk, meaning if a lawyer was completely ignorant of this topic, what kind of risk does that create for the lawyer and for the lawyer's clients? Next slide. In constitutional law, the Content Scope Committee felt strongly that there was a 4th factor that really needed to be weighed when determining whether topics were important enough for the bar exam. And that is the consideration that all lawyers are custodians of the Constitution and in that role need some knowledge about constitutional law topics, even some topics that may not come up frequently or across multiple specialties for new lawyers. Next slide. Once we determined which topics were considered important enough to be tested, we went further to decide how deeply those topics should be tested. And we considered a couple of different levels of knowledge. Level 1 being general familiarity with that topic. That means newly licensed lawyers should be able to, spot that topic in a scenario, work efficiently with legal resources relevant to that topic, and basically know when to go look it up, go do additional research to refresh one's memory about the specifics of the doctrine relating to that topic. Level 2 meant a more detailed knowledge of the doctrine, where a newly licensed lawyer should know some details about the doctrine related to that topic without consulting legal resources. Again, we thought about 3 different factors in determining which topics should be tested at a deeper level, and those included the complexity of the doctrine related to that topic, the context in which the topic usually arises, and by that I mean, does the topic normally arise when the lawyer has to act very quickly on behalf of the client in an emergency kind of scenario, or does the topic usually arise in practice when the lawyer would have an extended period of time to research? And then finally, we thought about whether the rule components related to that topic are stable and relatively universal across jurisdiction boundaries. Slide. Ultimately, the Content Scope Committee recommended many topics to be retired from the existing scope of content of the current bar exam, and that those topics that continued to be tested on NextGen, many of those topics be tested without recall of that detailed level of doctrine. So there would be less breadth and less depth of knowledge on the NextGen exam. Slide. The Scope Committee also looked at those 7 foundational skills. And in order to define specific exam tasks that examinees would be expected to perform on the exam in order to demonstrate those skills, we started with the practice analysis. That analysis had already identified dozens of lawyering tasks that newly licensed lawyers do. And so we looked at all of those tasks and began to define exam tasks that were aligned back to those lawyering tasks. We then talked a lot about universality and balance, how exam tasks might be constructed to cross over multiple different areas of specialty and multiple different lawyering tasks, and how they could be balanced, especially for transactional work versus litigation work. And then finally, we talked a lot about the cost and practicality of a written exam. NextGen will continue to be a written test, not a sort of an in-person performance. And so that did have some constraints on the kinds of examinee tasks that we thought could realistically be tested. Slide. Ultimately, there were 24 examinee tasks that the Content Scope Committee identified. We split them into 8 Group A tasks. Group A meaning issue spotting and analysis and investigation and evaluation. 7 Group B tasks. Those were aligned to client counseling and advising, negotiation, dispute resolution, and client relationship and management. The committee identified 2 research tasks initially. However, they also recommended that NCBE continue studying research, which is relatively new to us, and that we bring in more experts to advise, because this particular committee thought that 2 research tasks did not really get at the range of research skills that newly licensed lawyers needed. So they recommended that work continue, and in fact it has. We have brought in a wide range of experts on research, and we are now working with a total of 6 research tasks and attempting to construct prototype questions to test those tasks. Finally, we had 7 writing and drafting tasks initially identified by the Content Scope Committee. Next slide. The final committee recommendations were a product of multiple detailed subcommittee reports. So there were subcommittees within the larger group that looked at each of the subject areas and each of the skills. And all of those subcommittees produced reports for the larger committee. The larger committee then met and reviewed and discussed those reports. And if you can believe it, 21 lawyers and law professors approved those reports unanimously, except for one report that had one single negative vote. So there was widespread agreement with these committee members. Slide. The breadth and depth of foundational concepts and principles, as well as the lawyering tasks that have been identified to date, were published in the spring and can be found still on the NextGen website. We invited public comment and we received hundreds of comments on the content scope. We are busy looking through all of those public comments, as well as continuing to refine those outlines. And we expect final outlines and final list of tasks to be published in the spring. Slide. I'm going to turn it over to John Lee, who will give you some perspective from an academic outlook.
Thank you so much, Beth. I am excited to be here and to share my experiences both on the Content Scope Committee as well as prototyping. So a little bit about my background, which is why I've probably been asked to serve on this committee as well as in prototyping. I started the bar program at Carolina in 2010. It was the first full-time faculty member who was helping students with bar support. And of course, that has expanded nationwide. I've taught a variety of courses from contracts, torts, property, evidence, remedies, legal writing, PR. You kind of get the picture, right? And that's important in part because our NextGen exam will be an integrated exam. Slide. So, as a member of the Content Scope Committee, we started with the 8 subject matter areas that were identified. And each of those, in some sense, is a silo. You have contracts, evidence, torts. But a client won't come into your office and say, I have a torts problem. Can you tell me the rule on X? Right. So in part, we had to think about sort of how would this naturally arise in practice, right? What subject matter areas and what subtopics frequently arise in practice and might arise together. Next slide. And so in doing so, we thought about newly licensed lawyers and how they work. So for example, I served on 3 of the subcommittees, including property, an area that I teach in. And our subcommittee talked a lot about, what are the most common issues that our newly licensed lawyers are seeing in practice, right? And immediately what came to the fore was housing law, right? Landlord tenant law, which is currently tested on the current bar exam, right? But in terms of focus, that was an area that we wanted to prioritize and test at a deeper level, what's called a level 2, right? So detailed knowledge. By contrast, there were other areas that are currently assessed at a level 2 on the bar exam that either come up less frequently, or if they do, it comes up in such a context in which a lawyer would have time to go and do the appropriate research and then come back with an answer, or they would associate with a lawyer who was more experienced in that area. And so what we tried to do was to identify, right, what was important enough that it should be tested at all, and then if so, at what level, based on those considerations. Next slide. And so in the end, and I strongly encourage all of you to go and take a look at the content scope outlines that are posted on the NCBE site, in large part because the default for what is there is what is called level one knowledge, meaning that students or examinees will need to understand, from an issue spotting perspective, sort of factually when things are being implicated, but not necessarily know detailed knowledge. But then there are some things that are on the current exam that are gone altogether. So, for example, I teach torts. I served on the torts subcommittee, the privacy torts. There are a number of them, a hodgepodge, that some states have, some states don't have. Some states, have certain elements and others don't. And so, because of that lack of consistency from state to state, and the fact that they don't come up quite as often, that won't be tested on NextGen. Another example are what we call other doctrines. And by that, almost every subject matter area has a catch-all that would cover other rules, special doctrines. We did not just get rid of all of them, but rather we looked through those and saw, okay, are there ones within this list of 5 that make sense to test, either at a level 1 or level 2? But the default was not inclusion. The default was exclusion unless there was a reason to include it, right? And so, again, I highly encourage you to go and look at that. What is equally or perhaps more important is limiting detailed knowledge, memorization in larger swaths of the law. So, for example, in criminal law, examinees will not have to have detailed recall knowledge of the elements of crimes. So currently on the exam, examinees have to know the elements of common law crimes: robbery, burglary, battery, assault, and or the MPC, model penal code elements, right? And on the NextGen exam, students won't have to know the elements. Rather, they will be given criminal law statutes that they will then have to interpret and apply. Now, that doesn't mean that our law students shouldn't take crim law, right? Because they will have to understand mens rea, right? And understand when they see a knowledge-based crime, what that means. But they won't have to know that possession is a knowledge-based crime, right? That will not be part of what is being tested. So again, I would take a look at the content scope outlines. If something is not asterisk there, then it would not be tested at a recall-based knowledge. Next slide. So that is what we did on the knowledge side. We had a special subcommittee. It was larger than the other subcommittees that was focused on skills. And this group of individuals included clinicians, skills faculty members, legal writing, legal research, and practitioners. So I served on this committee as well. My background is in legal writing, and I was a clinical faculty member. So some of these skills are being currently tested on the bar exam: legal writing, evaluation, issue spotting, but some of them are new from an examination standpoint. So things like client counseling and advising, client relationship and management, and negotiation. And so we had a lot of discussion on sort of how do we take these really important skills and break them down in such a way that in a manageable amount of time, we would be able to fairly and accurately assess whether examinees were competent in these areas. Next slide. And so some of these skills won't be fully tested on a written bar exam. I mean, in part, we just don't have the time for it, right? It would be ideal if we had a 1 week exam where we brought in sort of artificial clients. Ideal, but not practical, right? But you can test components of many skills. And so what we did was break down the skills into lawyering tasks. Next slide. So here are a couple of examples of the lawyering tasks that are currently identified on NextGen. So if we give a transcript of a lawyer's interaction with a client, identify gaps in information obtained and ways that the lawyer could improve their effectiveness. Another example, in a client matter, list 2 to 3 outcomes in which both sides might be satisfied, right? Now, on the exam, there might be 4 or 5 possibilities, right? That would all be correct answers, but we are asking them to list 2 or 3. And so these lawyering tasks are also in the content scope outlines. And when professors ask me what might NextGen look like, especially from a skills perspective, I would encourage you to take a look at those. In fact, I am using those as a guidepost as I'm thinking about how to construct questions in my own classes, right? Because these skills are ones that can apply in a variety of subject matter areas. Next slide. Now, one part that is exciting to me, I'm a PR professor. It's the area that I write in. I promise I didn't twist their arms to include this. There was consensus. But some skills, especially as we are testing these new sort of client-centered skills, things like client counseling, client relationship and management, a newly licensed lawyer needs to have facility with the rules of ethics, right? With their PR rules in order to know where the boundaries are, right? That some of the things that otherwise they might wish to do, they cannot do because of our ethical obligations. Now, this is not a comprehensive examination of the model rules of professional conduct. Instead, is limited to the rules that would naturally arise in the context of a lawyer-client relationship. So, for example, conflicts of interest, confidentiality, candor to a tribunal, right? So these sort of again, lawyer-client context type of rules. And so these will not be tested in a vacuum. That is not the idea. And certainly more broadly, the skills aren't being tested in a vacuum either, right? The idea is that this will be integrated in where it would naturally arise. Next slide. So as we had conversations about the scope of skills, and again, as we're moving from identification of content and skills to be tested to sort of how we test it and prototyping, there were a few guide stars that were made known among those of us on this subcommittee. First, using realistic prompts and tools. And by that, I mean not requiring examinees to learn some artificial system for doing something, right? So, for example, on the research side, there are a variety of commercial databases that, or free ones that students may use for research, right? We don't want to sort of assess them on some particular technology, even if it's used, by some people. And we certainly don't want to have an artificial system, right? That people would learn something that was just for the bar exam, and then they wouldn't, use it in practice. Second, really ensuring that we balance transactional context and litigation. And this is something that we are constantly talking about, I think, in law schools as well. We've always, or at least traditionally, law schools have been litigation focused. We've been moving away from that. We want to do the same on the bar exam as well. Third, and this is a really interesting one to me, is making sure that the NextGen exam includes authentic interactions with clients and others. And this has a couple of components. One, we all know that clients don't come to us with neat, pre-packaged explanations of the facts or law, right? They might be verbose, they might just answer exactly what we ask, but what we know is they won't tell us everything immediately, right? And so we don't want to have on an exam something that doesn't match sort of real life. By the same token, we don't want to role model bad lawyering on the exam, right? In terms of like an interaction with the lawyer and client, unless we are testing bad lawyering, right? Instead, we should be role modeling good lawyering and sort of, the wide variety of clients with whom we might come in contact. And then last, marrying foundational concepts and skills, right? We want to test skills in the context in which they arise. If we just test doctrine and we just test skills, one, it will take a lot longer, and two, that is not how it happens in practice. Next slide. So a few takeaways that I've been thinking about as I've been doing this work. I think our NextGen Bar Exam, preparing for the bar exam for our students slash examinees, will be much more like preparing to serve clients. And that is exciting to me as someone who has probably assisted thousands of students prepare for the bar exam, that, although it's never going to be an easy process, at least if that connection is there, it feels like there's even more payoff, right? Second, in the classroom, just reinforcing teaching of foundational skills, which is something that we increasingly have been doing in legal education, not only in our experiential learning courses, our clinics, our internships, our externships, our skills-based courses, but also in our first-year courses, our core and doctrinal courses. Third, focus on conceptual understanding and knowledge management. And this is really important, I think, for those of us who are wanting to ensure that our students are learning what they need to learn, both, to the extent we guide what we might teach in class based on the bar exam. Having less content that students are memorizing actually frees up us, and by us, I mean those of us who are educating students to think about, like, what do I want to focus on in my class, right? What skills and what doctrine do I think is most important for my students to learn? And again, knowledge management being key in the practice of law. Of course, you don't know everything, right? You need to identify what the issues are, do the research so that you can advise your clients. And then last is thinking about ways to use practice to integrate skills and doctrine. In fact, about an hour ago, I was talking to someone who had seen our first presentation. I said, like, what does this look like in practice? And I said, I teach contracts. My first contracts assignment puts the students who are probably in their third week in law school in the role of a lawyer advising a client, right? And the client comes to them with a a piece of a contract that they found online, and they have to sort of evaluate it, right, and then provide some ideas and balance things. Like on the one hand, you could add this language, but that might make the other side a little bit concerned, right? So it's like adding in those client counseling skills in a doctrinal contracts class is an exciting thing potentially for some of us. Next slide. Okay, I'm super excited. I'm always excited, but I'm really excited to give you a sneak peek of prototyping, because I know that probably a lot of you who are watching this webcast want to know what the next gen questions are going to look like. Okay, so over the last 6 months or so, I've been on several of our prototyping groups, right? And those are multiple legal educators who come together in a variety of areas to think about how to craft assessments that will fit NextGen. Next slide. So one of our new item types is an integrated assessment. Think of this as like a case file, right? Or client matter. And what we think will happen, right, virtually or on the computer, is that the examinee will get some set of information that will test their ability to show some legal skills in the context of multiple areas of the law. So this particular assessment initially involved evidence, criminal law, and client counseling and advising. Next slide. And this particular example was actually based on an actual clinic case, right? So one of our committee members had a clinic case, and we modified that for this prototype. So the scenario raises issues of criminal law and evidence. We get a police report. We get a statute that deals with assault and battery, and a very short excerpt from a case that interprets this statute. Next slide. Then the students, the examinees, would see a prompt, and it would start with, you are an assistant prosecutor assigned to work on a battery case. Notice the you putting the examinee in the role of a newly licensed lawyer. And then they would get actual documents that would have sort of facts that they would need to read about this case. Now, one thing that we talk about extensively in our meetings is, what do these documents look like? And that we want them to be authentic. We don't want them to not reflect the types of documents that lawyers would see in practice. At the same time, we don't want to advantage or disadvantage students by using terminology that may not be familiar, right? And so that's a balance, and also thinking about timing, right? But again, that's just part of this process. Next slide. So then they would also see a jurisdiction statute about battery and aggravated battery. So I have a confession. My confession is, when I was first on this committee, I got my assignment, and I wrote up my initial draft. I sent it in, and I immediately got an email back. And they said, John, you didn't do it right. Right. And the reason I didn't do it right was I came from a jurisdiction in which the crimes start with, this state follows the common law of crimes unless otherwise modified by statute. And the jurisdiction in which I am licensed has lots of modifications, but they use that as the underpinning, right? But that isn't what we are doing for NextGen, right? Level 1, we have to give the students the elements of crimes. And I had written it such that students would have to know the common law elements of crimes. So I fixed it, right? But that just gives you an example of the sort of work that goes into these type of assessments. So this particular one had a statute for battery and aggravated battery. Next slide. So after students, examinees, sorry, I always say students because I think of them as law students, examinees, read through these documents, they would get a variety of prompts. So the first prompt says, what fact from the fact set would be most helpful in proving the element of knowingly? This is not a multiple choice question. Instead, examinees would write, very short, right, what that fact is. Second, list 3 avenues you would pursue to gather other evidence relevant to the issue of great bodily harm. This is an investigation task, right? Now, these avenues would be apparent from reading through the fact pattern. There would be more than 3 possible answers as well. So students would not have to identify, find those 3 things. There may be 5 or 6, but examinees would be needing to answer 3 of those. Third, a multiple choice question. So if you read this question, it's about a police officer testifying. This sounds like, and in fact it is, a hearsay question. There may be, and were 4 answer choices. So for those of us who have prepared students to take the bar examination, this might look more like a traditional multi-state bar examination question, right? But it's in context, right? In that, students will be, examinees will be thinking about this case file, thinking about that it's criminal, it's battery, there's a police officer, right? So it will feel more seamless, right? That it is integrated in this way. Next slide. So after examinees answer those 3 questions, they would then get more information about this scenario, right? They would get a transcript of a law clerk's interview with a witness, and then they would learn about several outstanding issues they had heard about earlier as the case unfolds. Now, I want to stop there and say, uh, I've heard some questions about these sort of integrated assessments where people have asked, well, if I miss question 1, if I get question 1 wrong, will I miss questions 2 and 3, right? And the answer is no. When we create these prototypes, they aren't stacked in such a way that you have to get 1 right to get 2 right and 3 right. And that could be problematic, right? Instead, we write them in such a way that they are independent in terms of what they are assessing. Next slide. So then examinees would get more prompts. Now these actually look like the lawyering tasks we saw and I talked about earlier, right? So they would look at the transcript of the witness interview and identify 2 errors that the law clerk made. Also, counsel may have proposed a plea deal that would be favorable to their client. List concerns as a prosecutor that you would raise. And there would be other possible questions as well. So in the end, there may be in this integrated assessment 4 to 6 prompts, but some of them have multiple things that examinees would be providing. So that could be 10 or 12 things, right? Ways in which we are assessing an examinee, right? And there are some advantages of that, right? In that it gives examinees multiple opportunities to show that they are competent with both skills and doctrine, right? And in terms of timing, at least the goal here is that this would be shorter than a multi-state performance test currently is. It's currently a 90-minute assessment of skills. And many people think it's an excellent assessment of skills, but it is 90 minutes. And so this would be shorter, which means that there could be more of these potentially on the exam. Next slide. So in the end, that prototyping assignment that started with evidence, crim law, and client counseling and advising actually ended up with evidence, criminal law, and then 4 sets of skills, right? All of which were part of this integrated assessment. Next slide. So you might be wondering, outside of the integrated assessment, are there other types of questions that we are drafting as prototypes? Are there things that look kind of like the MBE multiple choice exam questions? And the answer is yes, but they aren't necessarily constrained to that format. So here's a draft prototype question. So I would first invite you to look at the answer choices. There are 6 of them, right? There are not 4. And if you read those, for those of you who know these areas of the law, we've got some torts concepts, we've got some property concepts, we've got some contracts concepts, right? And so the prompt says your client has contacted you to advise them of their legal rights. We would then have some facts that would follow, and then the question is, which of the following state law doctrines are most important to research prior to giving the client advice? Select 2. So a few other things. First, your client has contacted you, right? So putting the examinee in the role of a lawyer advising a client. Second, this particular question will not require the evaluation of a case, meaning that I don't have to have detailed knowledge of the doctrine of any of these areas of the law. Instead, I need to know, based on the facts, what legal doctrines are implicated, right? So this is great for those level 1 type of questions where we want to make sure that our newly licensed lawyers know what to research, right? I'm not expecting them to, on the fly, have an answer. Next slide. So in the end, this particular type of question may involve torts, contract law, I would argue actually property law as well, and also assessing skills like issue spotting and analysis, as well as legal research. Next slide. So this is another example of a prototype question. Again, it starts with you, right? So you have a client who is charged with burglary. And then the question itself, again, there are some dots here because we can change what the fact pattern is to implicate various issues. In this particular case, it's an evidence question involving a prior criminal conviction, which may be brought in for impeachment purposes or for other purposes. The call of the question is sort of what should you do as a lawyer? How would you advise your client who wishes to testify? Now, what's interesting about this question, for those people who are PR people or even not, you've been practicing law, some of these answer choices are actually unethical, right? So answer choice A and D are unethical, right? You can't mandate that your client testify. You can't say that they cannot testify, subject to some limited exceptions around candor to a tribunal that are not implicated by this fact pattern. Next slide. So in the end, although this is testing evidence, a little bit of crim law, it's really testing as well client counseling and advising, as well as PR. So this is a good example of how PR issues, ethics issues might arise on the bar examination. exam examination, right? In that they won't be tested in a vacuum, but rather they would come up much more naturally as an examinee is evaluating options. We want to ensure that the option that they choose is not an unethical one. And so, with that, next slide, I will hand this over or hand this back to Beth to tell us more about pilot testing.
Thank you, John. So I'll talk a little bit about how we plan to go about testing all of these new prototype questions. Next slide. We have some short-term goals and some long-term goals. Our pilot testing is scheduled to kick off in November, although we did a little bit of work this last summer with a very small group of recent graduates, some of whom were licensed already, just to test out the platform that we will be using for pilot testing before we start opening up pilot testing to larger groups. But we will officially start our pilot test kickoff in November, and we will be pilot testing all the way through next year. At the end of next year, we are likely to advance into what we're calling field testing, which will be a much more formal test process involving the actual software that we plan to use in NextGen, and much more formal environment for examinees that will be more similar to what they will experience on the real bar exam. But for our short-term goals, we hope to first of all determine the impact of providing legal resources during the exam. So you saw from the prototypes that John talked about that some of these new item types will have different resources from a client file type. If you're familiar with the MPT, it would be sort of like a condensed file. MPT-like writing the tasks will likely remain on the bar exam. So there will be some shorter files, some longer files, some library-like materials. But we also will be studying the effect on examinees if we provide the federal rules of evidence throughout the exam as a reference. That was something that the Content Scope Committee suggested we study. They felt that it was really important to practitioners that you carry your federal rules of evidence with you everywhere, and you wouldn't be answering questions without those rules in front of you. So we're going to study that and see how that impacts examinees. Especially, we're going to be looking at how long examinees will need to answer new question types, both with or without additional references like the federal rules of evidence. And then we're going to be looking at developing grading rubrics. These short answer questions that have been defined in these examinee tasks list two avenues you would explore for additional information. Which fact from the police report is most relevant to a particular issue? All of those short answer questions, we are developing grading rubrics. That's a new item type for NCBE, and we're developing grading rubrics to use with those questions. And we will be getting subject matter experts to review all of those rubrics as well. Slide. Looking forward, as we get a little bit deeper into pilot testing, and much of this will be designed to be iterative, so that what we learn from the first wave of pilot testing will help feedback into the drafting process and the development process, as well as into the grading process. But as we move forward, we want to be looking at how to optimize the provision of legal resources, again, in a way that is fair to all candidates and that allows candidates to move efficiently through the exam with the time that they have. Next slide. And we also want to look at interface and user experience issues. This would be something likely that won't come up until we get to field testing and we're actually using a platform that we expect to use in practice in the real exam. There will be a number of different options for us in building out how these resources and how the questions appear on the screen. The flow of the exam, how examinees move through the exam, and how they access different resources, whether there are different windows or split screens, screen real estate use, stuff like that we will be looking at, as well as the combination of question types that work best for different subject areas and different skills. We will be testing the grading rubrics with real bar graders. That's going to be a big effort. And we will be facilitating a standard setting exercise for jurisdictions to study where they want to place their cut scores or their line between passing and failing. Next slide. Throughout all of this, we have an awesome research psychometric staff, and we have people specifically focused on diversity and equity. They will be looking at diversity, making sure that all of our pilot and field test participants, we have diversity there. We have diversity in our item drafters and reviewers who are working on developing new test questions, and that we have diversity in those folks who volunteer to participate and contribute to standard setting exercises for the jurisdictions. We're also looking at equity issues, definitely looking at universal design in the screen, in the user interface. And I know many of you are extremely interested in access to resources and especially sample questions. Those are coming, I promise you. We want to be very careful that we release, and we will release as questions sort of graduate from pilot testing, and we find questions that we just know this is going to be a model to move into actual production for more serious field testing, as well as for the real exam. We will release those sample questions as soon as they graduate out of pilot testing. But we don't want to start publishing anything before we are confident in those samples, because part of this process, as I said, it's iterative. Things may change the way that we go about drafting, and some item types that we're really excited about now, it might turn out that they simply don't graduate, they don't work, and so we don't want to put those out too soon. Next slide. That is all our presentation for me and John. I think we're going to hand it back to Marilyn and then start taking questions from the group.
Thank you, John and Beth. That was very helpful. We are looking forward now to answering some of your questions. To do that, I am welcoming Sophie Martin to the group. Sophie will be managing our question and answer session now. Before we get to that, I just want to make a special note. You'll see on your screen a QR code. That QR code will take you to our NextGen website and allow you to sign up for updates on things that are going on and progress that we're making on NextGen. So I encourage you to use that QR code and to sign up for those updates. We will be providing many methods to update you on things, but that is one sure way to keep yourself apprised of what is going on. So with that, Sophie, can you give us our first question?
Great, and thank you everyone who's already submitted questions into the chat. We are sorting through them and trying to group them a little bit, so you may not see your question come up, but hopefully you'll see a question that encompasses or get an answer that encompasses what you're interested in. And then, as was mentioned at the top of the session, any questions that we can't get to today for time reasons, or if you submit them later, our plan is to go ahead and answer those questions for you after this session, and you'll get a follow-up email after this is done letting you know how we'll do that. Let's go ahead and start with that first question, which is, when can we expect that the content scope for the new exam will be finalized? And Beth, I'm going to throw that one to you.
Sure. We are refining that now based on public commentary that came in to us in the spring, and we hope that we will have the final content scope next spring.
And then there's a follow-on question that I'm just going to say verbally, which is, there was a question about the 6 research topics. Will those be added to the revised content scope outline?
Yeah, those will be as soon as we have proof of concept questions so that we're fairly certain we can develop questions in those tasks. We will likely release those even before next spring.
Wonderful. I think this next one goes to Marilyn, at least to start. When will the old subjects be removed from the current exam? For example, family law, secured transactions.
So we are working on the current, as you all know, we draft exam items well ahead, and we're working though to, as we move forward, align the topics on the current exam with what will be on the next gen exam. So it's a process. It'll happen over time, but we will, as we move forward in drafting, we will work very hard to make sure we're more closely aligning the topic areas between the old exam and the new exam. That said, the current exam topics are still all testable topics and will continue to be potentially testable topics. But those changes, we will work on those moving forward in the next couple of years to align the two areas of the two subject lists of subject matters with NextGen and the UBE.
Okay, I'm going to skip over a couple because I think that some have been answered, but we have one. Will the next gen exam get rid of the MPRE or have other impacts on the MPRE?
I think I can take that. The short answer is no. The MPRE is expected to continue. We feel that the MPRE is an important deep dive into the rules of professional responsibility, but that certain specific rules, likely 10 or I think there are 10 or maybe 11 rules, will then be tested on the next gen exam, as well as John Lee discussed, sort of as integrated with client counseling and advising skill.
Great, thank you. I'm going to, again, for the group, I'm going to move on to how much time will be given to perform each task type on the new exam. And I think, Beth, this might be you.
Sure, we don't know. That is a major goal of pilot testing, or a short-term goal. We are looking at how long examinees take. We have a pilot testing platform that actually tracks how long each person spends on every question. And then we also ask a number of questions about the pilot test experience for an examinee who answered questions. Some of those questions that we ask as survey questions are related to timing. Do you feel, how much time did you take? Even though, we are also tracking that in real time. How much time do you think this type of question, or this cluster of questions should take? How much time do you think that you would need if you had resources available? So we're asking a number of questions related to timing, as well as tracking the time that examinees actually take. And we have psychometricians that will be working on evaluating all of that data, as well as thinking about, of course, we know that pilot testing is not as stressful as a real live bar exam experience and under bar conditions. And so we will be moving from pilot testing next year into a much more formal field testing environment that is the actual real test platform that the next gen exam will appear on, and has more exam-like conditions, longer periods of testing potentially, because we also know that there can be sort of a marathon effect, where your timing might be different in the first 30 minutes of taking the exam than it is in the last 30 minutes of a long day of test taking. So we're looking at all of that with the goal of having a reasonable time for every single item type. And in fact, one of the reasons that we are not releasing questions until we have confidence in them through this pilot testing process, we want to make sure that if there's a question type that we love, but it just takes too long, and the bar exam would be 12 days if we tried to integrate these questions, those types of questions might not make the cut for timing reasons.
Great. Our next question, how many integrated assessments will likely be on the next gen bar exam? And will it still be a 2-day test?
That is to be determined. Short answer. We don't know yet.
So I'll ask a follow-up on that. You've talked quite a bit actually about the pilot testing process. Do you have a sense of when a decision and then an announcement would be made about those matters?
After field testing, we will have final determinations on exactly how much time the exam will take and how many, which hours will be devoted to which item types. And a lot of that is we have to have a certain level of reliability for the jurisdictions to feel that they have, legally defensible, that they can take legally defensible actions in their pass-fail decisions. So we are looking at how all of these questions perform and what combinations of different types of questions do we need to ensure we get to that reliability. But we don't know if it will be a 2-day exam, and we don't know exactly what the breakdown will be of different question types yet.
Since there is less breadth and depth of content, will the bar exam be offered earlier than end of July?
The bar exam the current schedule for the bar exam will continue. The July and February administrations is a schedule that we feel based on what we've heard back from stakeholders, is a good schedule for graduates, recent graduates, and so we will maintain that schedule. It'll be offered in third week in July and the third week in February, as it has been. And as far as whether it still remains a 2-day exam, the schedule will be adjusted based on when we learn how long the exam will be. But that general schedule will remain.
Okay, next question. Will the questions be on paper for examinees, or will all of it be via computer? And Marilyn.
Sure. So it will be completely administered on computer. As people know now, in the constructive response portions of the current exam, most students will, or most candidates will type on a computer to type their responses. The difference is right now the questions are handed out on paper. With the NextGen exam, the questions will be delivered via computer and they will be responded to via computer.
And I'm gonna bring in a follow-up question related, which is, will that computer-based exam be in-person or remote testing?
It will be an in-person exam. It will be administered at jurisdiction managed sites as it is now. That's one of the similarities. So candidates will go to the jurisdiction managed site, bring their own computers, and the exam will be administered on the candidate's computers in that site.
Next question, how will NextGen address accessibility and accommodations from an ADA perspective? And either Beth or Marilyn?
I can start by saying that we will have some ADA expert guidance on a group that is going to be reviewing all of our grading rubrics. So we're looking at it from that perspective of are there differing abilities here that we need to take into account during grading. We are also going to have experts in sort of universal design and in user interface and user experience take a look at our platform and give us advice on how to set up just sort of the flow of questions. I will sort of piggyback on Marilyn's answer to the question about, is it computer-based? Standard testing will be all computer-based on NextGen. That said, we may still be doing some accommodations that are in paper. It's kind of the reverse of what we often see now, where the standard exam is handing out test booklets and answer sheets in the case of the MBE, but some candidates do test on laptop. So now we are, and most candidates are testing on laptop, as Marilyn said, for the written components. So everyone will be moving, the standard experience will be moving to computer, but we expect that there will still be various materials put together for based on the ADA. And jurisdictions make ADA decisions, not NCBE with respect to the bar exam.
And so I just want to add to that. Thank you, Beth. That this is part of pilot testing and field testing is determining what we will need to do to ensure that this exam is fully accessible to all candidates. And so NCBE will continue to work with jurisdictions who will be administering the exam and making accommodations, determinations to make sure that the exam is available to their candidates in whatever form it needs to be available to ensure full access.
Okay, next question. Do you anticipate that bar exam passage rates will increase with this new approach? And I think probably Marilyn.
Sure. We do not know how this will impact bar exam pass rates. The goal is to provide an exam that is valid and reliable in testing these the knowledge and skills areas. How that will impact pass rates, bar exam pass rates, is not something that is part of our development of this exam. The development of the exam is really based on ensuring a fair and reliable and valid exam experience. So we don't know how this will impact pass rates. And as you all know, there are many things that impact bar exam pass rates, many factors that impact pass rates. And so we don't know how this particular change will impact those pass rates at this point.
So I can add a point as well from the prototyping perspective. We talk a lot about this in passing, right? About like, oh, if we draft this question in this way, what does it mean, right? And so our guide star is minimum competency, right? Is what we are thinking about. Are our newly licensed lawyers competent? And we will sometimes say, wow, this is something that I didn't get in my doctrinal classes and I didn't get in law school. But it's certainly something that a newly licensed lawyer needs to be able to do, right? And it's something that we did often in practice, right? And so the way I see it is tailoring, right? It's about tailoring the exam in such a way that it assesses minimum competency. And if that does mean that bar passage rates increase, then that means that we are graduating students that are competent to be newly licensed lawyers. And I think that's a great thing, right? If it means that there are some students who are currently passing who may not be minimally competent, that is another issue, right? And so I just see it as a tailoring exercise, as we do in the academy as well, to ensure over time that our students who are graduating are prepared to represent their clients well.
Thank you. Okay, this one I think, John, will actually stay with you. Should we expect the classic no, yes, multiple choice answer choices to be used with less frequency?
I think the short answer is yes, right? In that, a lot of what we are thinking about is testing skills, right? And there are times when you can craft a question that has that no, yes style. But the reality of it is that law practice doesn't come in neatly packaged 4 answer choice designs, right? So if I hear a fact pattern, there might be sort of 3 possibilities that would be plausible, or 6, right? As you saw in the earlier questions. So there's, from a question creation standpoint, and I'm not a psychometrician, right? But I've learned enough, through this process to understand that there isn't anything magical about the 4 and the yes, no, right? And so that really frees us up to think more holistically and more realistically about how these questions may arise in the practice of law.
I will say, if I could jump in just for a second, I will say those questions, they generally perform well. They've been used extensively on the multi-state bar exam, and we expect to continue to see them. There are several of those no, no, yes, yes formatted questions that are in existing prototype item sets, those integrated collections of questions. But I do think it's fair to say overall that there will be fewer of those won't dominate necessarily the way that they have in the current exams.
Question, how do you avoid this test becoming a speed reading test rather than a lawyering test? And I think perhaps that starts with Beth.
Yeah, it's a great question, and it's really high on our list of priorities for pilot testing. We are looking for question types that we think examinees can answer in a in a day and a half to 2 days. We're not going to I said earlier, we don't know how long the exam will be. I can almost guarantee the exam will not be longer than it is now. And so within that time frame, we need to find the questions. We do not want the exam to be testing speededness. And so we already do a lot of work on speededness in our psychometric unit with respect to the existing exam components, and we are doing a lot of work before item types are finalized for actual development and production. We're doing a lot of that work now in pilot testing. So that's the first thing we're looking at. But I guess to answer your question, how do you avoid it being basically speeded is, well, you don't use the types of questions that where you see that being an issue.
Thanks. I'm actually gonna go with a question that I don't have in a concise form to share on the screen. I'm just gonna ask it. We've had a couple of questions asking, sort of circling around, will the MEE, MPT, MBE still be present on this new exam? So we've had some questions about what will be the balance in scoring and what will be the weight of each type of question, things like that. And Beth, can I ask you to start on that one?
Sure. So the current UBE components, MBE, MEE, and MPT, those will no longer be, they will not be their own things in NextGen. NextGen is designed to be a single exam, integrated exam. So not these separate components. Those exams likely will continue for a few administrations after the launch of NextGen, but they will be retired. As for the weighting of different components in NextGen, there will be different item types on NextGen, and as I said earlier, we don't really know how those will be weighted yet. A lot depends on how those different types of questions perform in pilot testing. So you may not have a 3-hour or 6-hour group of multiple choice questions that you take back to back, because those multiple choice questions may be integrated with other item types in these different kinds of scenarios. But there still will be multiple choice questions on NextGen. There still will be some kind of written component, likely a longer written component, similar to an MPT like format. The longer essays in the MEE, we have not had prototyped anything like that yet. We're really focusing on shorter answer questions in the constructed response universe. But all of those, so the official exam silos will disappear with NextGen. And I don't know if Marilyn wants to add.
Yeah. Yeah, if I can just add to that. So what we're calling the NextGen exam will become the uniform bar exam. So right now we have this uniform bar exam with the three elements, the three components, MPT, MEE, and MBE. That will retire after a few administrations, and the UBE will then be what the NextGen exam. It will replace the current UBE once we've moved all of jurisdictions over, all UBE jurisdictions over to the new exam.
Marilyn, I'm going to stay with you. Will the next gen exam be the uniform bar exam for participating jurisdictions?
Yes, then for those jurisdictions that adopt this next gen exam, that will be the uniform bar exam. And so the portable score that you receive on the uniform bar exam will be the portable score that is the next gen exam, which will, we debated early on whether we should be calling this the uniform bar exam now, because that's what it's going to turn into. But for obvious reasons of confusion, as we transition, we're calling it the next gen bar exam, but ultimately that will be the UBE that will be provide the portable score that is so beneficial to candidates.
John, I believe this next one goes to you. It is, what do you anticipate will be the most significant curricular changes law school will need to prepare students for the next gen bar? That's a big one.
How many hours do we have? No. So I think by and large, and I've been in the academy since 2009, and I was I was in law school a few decades ago. We've already been making a number of these changes, right? So I think about the expansion of clinics. I think about experiential learning. I think about cultural competency, right? Things that we have been increasingly put in place, because the skills side for me is where I see expansion, right? On the doctrinal side, I see contraction isn't the right word, but less, right? And so, from a doctrinal perspective, so I teach property and evidence, right? For property in particular, this really frees me up to think about sort of, what do I want to ensure that my students know coming out of property, right? And because there is less detailed knowledge required, to the extent that some faculty use the bar exam, or at least look to the bar exam for some of the content areas that they might cover, right? That they will be free to think about what they want to cover. But from a skills perspective, I see this as really in line with the trajectory of where law schools have been going, right? And so it's interesting to me that, on the law school side, from the academy, we have identified certain skills as being, among the most important skills that students need in order to be newly licensed lawyers. Independently, NCBE, through their practice analysis, has come up with a very similar set of skills, right? And so, though one is not necessarily pushing on the other, right? I think that both are sort of independently coming to that same conclusion. And so I see that just continuing, right, in terms of the trajectory that we are already seeing. Now, it might mean that some schools might work more quickly towards that goal, right? But again, it tends to be those skills that we've identified already as being important.
Thank you. I think this might go to Marilyn, this next one, which is, when will the old subjects be removed from the current exam?
So we are working to align the current exam subjects with the new the topic areas in next gen. The exam is developed over time. Questions are developed in advance. So we will continue to work as we move forward with questions on the current exam products to align them more closely with what will be next gen. That said, the topics that are on the current exam in the current exam outlines remain, possible testable items, but we will continue to work towards the alignment of the two exams as we move forward.
This may also be a John one. How will we measure subjective attorney decisions on an exam?
Wow. So that is something that we have a lot of conversations, right? We want to ensure that we have fairness, right? That if we are going to assess students on particular skills, that they know what they are being tested on, right? And that may mean, as we are constructing questions, we have come to a point where we say, wow, there's no real fair way to ask this particular question in this way, right? And then from my perspective, at least, it means that we can't ask that question, right? Because I do not want to disadvantage students based on strategic questions where reasonable minds may differ, right? And so again, I think part of this comes from as these question types are developed and as we have more granularity around what the content and skills are that are being tested, that there is transparency and that we tell students, right, examinees, how things will be tested. But I think the question gets at a critical point, which is we cannot truly test things that are subjective, because at that point we could be disadvantaging students based on experience, on background, on economic status, on things of that nature that I know, or from what I hear, I'm not NCBE, but from everything that I'm seeing, that is at the forefront of what they are thinking about in terms of fair assessment.
I think I may be staying with you as well on this, John. What does dispute resolution mean when we talk about negotiation and dispute resolution? Would processes such as mediation and arbitration be included?
My understanding, and Beth can chime in as well, is that the answer is yes, right? But that we would want to identify more specifically, and would be identifying more specifically what would be included. That is not my area of expertise, and so I have not been serving on prototyping that is doing as much of that. So I will hand it over to Beth on that front.
Yeah, so the answer is yes, but we are looking at sort of basic skills, concepts, principles that would really apply to negotiation and dispute resolution, whether it's arbitration or mediation. We are not looking at, I think, things that would be specific only to mediation. I want to jump in, if I could go back as well to the previous question, to just add to John's statements about how do you test things that are subjective. And yeah, I mean, we're doing a lot of talking about that, and we're trying to find only those exam tasks where we think we will be able to fairly grade. One of the techniques that we may be using on NextGen, rather than having the idea of the perfect answer of, it should raise point A, point B, and point C, as you might see in a legal analysis being graded. Some of these types of questions where we ask examinees potentially to list 3 concerns, or list 3 points that you would raise, there may be multiple, right, way more than 3 answers that would be given full credit, and we haven't necessarily had that approach to grading in the past, but we're looking at different ways to grade these things as well. So it's not just it's in the drafting process, of course, and figuring out, can we do it fairly, but then also there will be some issues on the grading side where multiple answers might be counted correct. So we're that's very much being looked at in pilot and field testing.
Yes, and so I would just follow up on that, on a question that I have heard as I talk to my colleagues about NextGen is, will there be better answers and less better answers, right? Like partial credit, or like we really want this answer, and so we will give more credit for that answer. And my understanding, Beth, is that that is a no, right? And that gets to the subjective part, right? So if we say list 3 things and there may be 6, if you say 3 of those things, right, that are in those 6, you would get full credit, right? It is not that if you say one of those 6, it gets more credit than, 3 and 4. Is that fair?
So far, that has been the case. And I just want to say as well that once we are pretty happy with the grading rubrics we think will work for these short answer questions, we plan to release those grading rubrics as well. We want you to know, how we plan to grade these things. So there will be a lot of information coming that will help folks who are who work in the business of preparing students.
And this sort of I think comes right behind that. Will sample questions be available at no charge to students? And I think perhaps Beth or Marilyn.
The answer is yes. We have always provided some sample questions at no charge, and lots more for a very small charge. And NextGen will continue to do that.
We next have a question. I think this is for you as Beth as well. And the first part is, who are the pilot testers? But we had another question that was more specific, asking whether attorneys would be participating as pilot testers as well, or I suppose field testers.
Sure. So we had a very tiny group of 19 do an initial run to make sure our platform was working smoothly. And that group was a group of recent law graduates, about half of whom were licensed. Our first wave of pilot testing will include 3L students from a variety of schools from across the country, and that we will have several waves of pilot testing involving schools and 3L students. And then once we move into field testing, we're still defining exactly what that group will look like. It'll almost certainly be a mix of students and beginning attorneys. I don't see a scenario in which we'd have law professor experts or, practitioner experts who've been out in the field for 10 years taking the pilot test, because that's not, who we want to hear from.
Next question, and I think I would think this might be going to Marilyn, might be going to Beth. Will you be phasing in the new components of the bar exam, or will the old bar exam be entirely replaced by a new art bar exam all at once?
So I think I can respond to that. So the current bar exam, the current UBE, there will be a period of time where some jurisdictions are administering the NextGen exam and some jurisdictions are administering the current UBE. That will be a fairly short period of time, but there will be a couple of administrations where both exams are administered depending on the timing for each jurisdiction. As each jurisdiction adopts the NextGen or selects their date to move to the NextGen exam, that jurisdiction will only administer the NextGen exam. And then after a couple of administrations, all jurisdictions will be at the NextGen exam, and the uniform bar exam as it currently is comprised will no longer be administered.
I think, Marilyn, a question for you as well. Will the portable score remain the same, or will states have to develop or adopt a new published score?
So we will be conducting a standard setting study with jurisdictions to help them to identify a cut score or a passing score standard in their own jurisdiction. It will likely be on a different scale than the current UBE, which, as people know, is a 1 to 400, but the score ranges in the UBE jurisdictions range from 260 to 280. It's a pretty wide range. Jurisdictions there will be the standard setting study. Jurisdictions will be given good information and data from NCBE to help them to determine what their ultimate cut score is for their jurisdiction. But ultimately, the decision as to what that passing score is in a jurisdiction is a decision made by the jurisdiction, typically the court, the highest court in that jurisdiction.
Next question, and I think this goes to John and Beth. Can you talk more about how the test might test legal research skills? Will test takers be given materials, or will there be an open universe for research?
At this time, and I did say that research is lagging a little bit in some of the other tasks because of, in part because of, I think the spirit of your question, is there going to be, a link to a database, whether it's proprietary, whether it's some kind of other platform, or something that's a sort of a closed universe, fake database that we make up for purposes of the exam. And there's been a lot of conversation around those issues, and a lot of disagreement about that. Right now, we are looking to not have a sort of a, we've been thinking about research in sort of phases, and you have a phase where a client comes to you with a scenario, and you have to figure out, how do I get information? What do I need to research, and where do I go? What are my approaches to finding the information I need to help the client? And then there's this kind of second phase of research where you go out and do that research, and then there's a phase where you have to put all that together, and oftentimes it's iterative, right? You find information that sends you back down to to get more resources, to get more information. Well, we're really looking at a lot of the early planning and issue spotting. We are really confident that we can do that. And then we're also looking at, if you think about in the context of a multi-state performance test, you have your case file and you have a library, and it's kind of a limited library. We're looking at all the research we can do around those kinds of much more limited files or libraries in with respect to research. And we actually recently met with a group, including an MPT drafter, to think about how would we rework an MPT library to get at some really research specific type skills. And all combining those two things, we're pretty sure we're not going to need that sort of in between phase of actually typing in search terms and collecting search lists. And in part, we have timing really at the forefront of our concern about potentially including a component like that on the next gen exam. Issues related to leaving our platform to go to anybody else's platform create some additional logistical and security issues, but we're very worried about having timing be an issue, as well as one of the questions earlier about how do you grade that, right? Because uh, different competent attorneys might have different strategies about how they conduct their research and what search terms they use to get them to the right materials. So we are still talking about it, but we believe we're going to get at a whole bunch of really research specific tasks and skills without having a large database that is searched kind of in real time during the bar exam.
Yes, and to follow up on that, so I served on the skills subcommittee of the content scope committee, and we had a lot of conversations about this very issue. And one thing that came to the fore was we did not want to create artificiality, right, in terms of how we would test certain skills, right? And we know that among licensed attorneys, there are a variety of ways that one may access research, right? Some may have access to the commercial for pay databases, some do not, some have free alternatives. And so we wanted to be really mindful of that. Now, that is not to say that there could not be other ways in which the jurisdictions could sort of at least provide education, if not sort of CLEs or other types of things. If there are more specific alternatives, I know that some states, have fast case available for all licensed attorneys, and so that might make sense in that particular state. But the last thing we want to do, I think, as we are creating an exam, is to have students learn something just for an exam.
When will the content scope outline be finalized?
Next spring. We are right now looking at all of the public comments we got. We got hundreds of comments. I promise I am personally looking at every single one of them. As the whole editorial team is looking at all of them, and they'll be reviewed. Again, they'll be grouped, sort of like on now with your questions. They'll be grouped. They'll be categorized. We're looking at all of them, and those are feeding into refining the subject matter outlines. And so that will then be reviewed again by NCBE leadership, and final outlines and final tasks should be out next spring.
Can I
And
just add to that? Thank you, Beth, that the content scope outlines are available now on our website. And, they'll be refined based on the comments that we are receiving and based on the great work that Beth and her team are doing. But in the meantime, those content scope outlines that are there should be very helpful to you in looking at the content of this next exam.
thank you so much, Beth and Marilyn. Marilyn, that's about what I was about to say as well. This is a question I think I'm going to send to John. How did the committees, how did the groups make decisions about what will be included within each subject area?
Yeah, so that is an excellent question. We started by looking at the three guide stars that Beth talked about earlier, which is frequency, right? How often it comes up, how universal it is, and then risk. I mean, one issue that we talked a lot about is, there are a number of areas of the law in which there may be doctrine in every state, and yet it's very different by state, right? And so that would be an example of an area in which we would say, okay, we want examinees to have level 1 knowledge, meaning that they need to understand. I know I'm a property person, so I'm going to give you a property example. Equitable conversion, you may remember, is a doctrine in property law that deals with sort of risk of loss type of issues when a land sale contract is signed, right? It's sort of, where does that risk fall? But the reality of it is that common law doctrine has been changed in many states by statute, but there's not uniformity in exactly what the rules are there, right? And that would be a great place where we want examinees to know, oh, if I see an issue where there's a land sale contract and then a thing happens afterwards, I need to know what this doctrine is to look it up, but I don't need to know what the common law rule is if my jurisdiction doesn't follow that, right? And so that again is an example of an instance in which it would be level 1. By contrast, a level 2 issue would be one that comes up frequently and may come up in such a way that you would need to have more of an off the cuff answer, right? You need to be able to sort of quickly see something, right? Let's say in court, right? Or in another setting in which it would make sense to have level 2 understanding. But as I said, our default was not, let's put everything at level 2, meaning detailed knowledge, and then pulling back. Our default was more, let's put things, well, first, is it in the list or is it cut? But then it was, is there a reason to move it from level 1 to level 2, right? And there was not a unanimous answer always. I mean, we have 21 people initially, but through our conversations about sort of what types of things newly licensed lawyers do, we came to pretty good consensus on what should be included and what won't be. But I think that this is an ongoing process, which is in part why the final outlines will be out in the spring.
Thank you. Next question is, will the new exam include the MBE, MEE, and/or MPT? And I'm going to send that to Beth.
So the MBE, MEE, and MPT will be retired after the next gen releases, but not immediate. It's expected not immediately when the next gen releases, but the next gen exam is designed to be a one exam, an integrated exam. And while there will be certainly parts of that, the next gen exam, that there will be multiple choice questions, like questions that are on the MBE. There will be a lot of short answer questions that are kind of new to us. There will be items that probably look very similar to an MPT that lead to a longer written task. But the MBE, MEE, MPT, the UBE components will phase out after next gen launches, and I'll ask Marilyn to weigh in on. I'm not sure how long after, but they will not. They will be retired eventually.
So just to add on, and Beth, thank you for that. So the next gen exam is going to be the UBE. That it will ultimately be the UBE, but we're not expecting that all jurisdictions will transition immediately to the next gen exam. The next gen exam's first administration will be available in July of 26, and over a few administrations of both exams, there will be a period of time where some jurisdictions are administering next gen and some are administering the UBE. That will, over a period of time, that will ultimately sunset the current UBE, and the next gen exam will then be the replacement for the current UBE.
This is sort of a broad one, and I'm going to send it first to John. What curricular changes should law schools be making or thinking about making to prepare students for this next gen bar exam?
Yeah, so that is the $1,000,000 question that I get asked a lot when I tell fellow colleagues that I am on or was on the content scope committee. I have a few thoughts. First, I think a lot of the momentum over the last, say, 15, 20 years, expansion of clinical programs, experiential learning, skills courses. The ABA has new standards on cultural competency. I think all of those efforts are similar to the types of things that we will be seeing with increased frequency on the next gen bar exam. And from my perspective, at least, I won't speak for the NCBE, but as someone who has taught those courses, who has helped students prepare for the bar exam, that's really exciting, right? And there are really two aspects to it. One, from a doctrinal perspective, because the exam from a doctrine perspective will be testing less broadly, less deeply, that frees me up in my own classroom to be very thoughtful about what topic areas and what skills I will be teaching in class, right? And I do not align completely my teaching to the bar exam, right? But I know that, and I hear it from faculty, well, the only reason I teach X is because it's currently on the bar exam, right? And to not have to be thinking in those ways, to the same extent in the future. And again, taking a look at the things that are level 2, those are, many of them are sort of fundamental, like offer and acceptance and contracts, right? Like big concepts that you would probably be teaching anyways. From a skills perspective, I think that to the extent law schools want to ensure that their students are prepared for the bar exam, which again, as I said, because preparing for the bar exam is more like the preparation for practice, it may mean thinking about increasing offerings around skills, around interviewing and counseling and negotiation, mediation, increased clinical opportunities. But my sense of things is that law schools in large part are thinking that way already. And I would, I every time I present or talk about the next gen exam, I always offer up My email address is john.lee@ou.edu. I'm happy to sort of, if you have ideas or you'd like to talk about it, when I put on my legal educator hat and not my I'm working on prototypes for the NCBE hat, I am happy to sort of help you think through those issues as well.
Okay, I'm going to move on to a couple. Thank you. I'm going to move on to a couple of questions about pilot testing, which may also touch on field testing. And the first one that I have is, will the NextGen pilot include test takers with disabilities who use testing accommodations? And Beth, I'm going to say, you're nodding. I'm going to send that one to you.
That's a great question, and the answer is yes. Both pilot testing and field testing we are planning to include test takers with disabilities. Yes.
Thank you. And then still, I think staying in that general zone. So Beth, I'm going to stay with you. How much time will be allocated for an examinee to perform the exam tasks? And I'm going to add in, I think, a related question that also came in. How will you ensure that the exam is not speeded?
So our current pilot testing wave will provide examinees with what we believe is more than enough time for answering questions. We have a pilot testing platform that will actually record how much time every examinee spends on every question. So we'll have that data. They'll be allowed during the pilot to ask for more time if they run out of time, although I don't expect they would. And then we have a series of questions following each group of pilot test questions. We have a series of survey questions for the examinees to give us feedback on the items, and those survey questions range from, does this feel like real practice? Does this seem like it's at the right level for newly licensed lawyers? Was there anything confusing about the question? Questions like that sort of go to the substance of the items themselves, but also questions about timing. How long do you think it would take examinees to finish this question? How long did it take you? Did you feel like you needed more time? How quickly did you work through those questions? Did you feel like you were working at a fast pace or at a leisurely pace? So we have a series of questions that the psychometricians have helped to craft to try to get at how should these things be timed. We do not want, it is not the purpose of NextGen. We do not intend to produce a speeded exam. And so we are working our way through all of those questions in pilot and field testing to make sure that the time allotted is reasonable. Of course, I should add, there will always, for a variety of reasons, be examinees who request extra time as an accommodation, and those accommodations are reviewed by the jurisdictions.
I'm going to actually pick up, Beth, on that last thing that you just said. We have a question that starts with, many students with disabilities are requesting testing accommodations. Do you anticipate that more test takers will seek accommodations with this new format? And Beth, I think I'll stay with you, but obviously Marilyn or John, if you'd like to jump in.
We expect it's a hard prediction to make, and the truth is we don't know. But we expect many of the accommodations that we currently see related to examinees with visual disabilities are requests for larger print or audio or an ability to use a laptop with screen reading software. So in the NextGen exam, all of that will be already part of the exam on computer. So the examinee will have the option to change the font or to potentially to reverse the background color and the font color. We see that request sometimes. Screen reading software will be will work with the exam as it's produced for the standard examinees as well. So a lot of that will be built in. We hope that means less need for special requests for accommodations, but we just don't know. We know that when we move to computer, there will still be some examinees that, for a variety of reasons, actually need a paper copy of the exam as an accommodation. And so, again, the jurisdictions make those accommodations decisions, and we will continue to work with jurisdictions to make sure that they're getting what they need to put in front of the examinee, to make sure that the examinee is accommodated and has access to the exam.
Okay, next question. I think this is to you again, Beth. Will the multiple choice questions still serve to scale the written questions? And I realize that might be Beth, that might be Marilyn.
That is a good question. And I wish my boss, who is a psychometrician, were here. She might be able to answer it better than I can. The short answer is I don't think we've decided yet. Many of the short answer questions, we are going to be considering whether those questions can be pre-tested and then repeat tested over time, like the multiple choice questions are now. And if that's the case, we'll have a lot more information about those constructed responses going into a live use on the exam, a use that is not just being for pretest purposes or field test purposes, but a live use. We'll already know what the statistics are on those shorter constructed responses, and so that those scaling issues may change. But I'm not a psychometrician, so we will follow up if I answered that incorrectly.
I just want to add to that, and Beth, I don't think you answered incorrectly from my understanding. Also not a psychometrician, also a lawyer, but I will say too that one of the efforts that one of our goals in this is to make this a shorter exam. Right now, as you all know, this is a 12-hour, the UBE is a 12-hour exam. And one of our goals is to bring that down, to bring that time down. We're still working because ultimately the key is making sure we have an exam that's reliable. So we're working with the psychometricians to make sure that we're developing something that's reliable. But if we can bring it down to a less than a 12-hour exam, we may need to use some multiple choice questions to help anchor that and help increase that reliability. Again, this is a psychometric issue and we're relying on our psychometricians to make sure we get this right. But that said, we may need to use some multiple choice questions if that allows us perhaps to meet a goal of the highest level of reliability and an exam that is less than 12 hours. But that all remains to be seen. People are working very hard on it, and that is certainly information that we will share as soon as we have it.
Thank you. This one I think goes to John. Comment first and then a question. It seems like student success is based on professors' adaptability for teaching skills and client counseling in 1L doctrinal courses. Would you agree with this?
Adapting for teaching skills. I'm trying to think of yeah. I'm working through this question. So I think that student success is based on the ability to take doctrine in 1L courses and then to apply it on an examination. So I don't have a great answer to this. So I'm going to just sort of change it slightly, which is what I do as a professor, and answer the thing that I think is more appropriate. And it's not appropriate, but like something I feel strongly about. I think it's really important when we are thinking about having an examination like this, that really means the difference between someone being able to go and practice and someone not, that we have a fair exam that will not be, from a grading perspective, be based on the subjective views of the particular graders, right? And so something that we've been working with a lot as we're thinking about how to assess skills, right? Because some people might say, well, certain skills, soft skills, are very subjective in nature, and sort of how do you assess those. And, I take that to heart, right? That if we want to assess skills, that we have to be very transparent in sort of how we are assessing them and ensuring that we do so in a way that is fair and equitable, right? And so there have been times as we've been trying to construct questions that get at skills where several of us as faculty have said, you know, I can't come up with an objective answer here, right? Meaning that I could imagine a student saying, well, I believe that this is the right answer based on, this, particular scenario or balancing strategy with what the law says. And I think in those instances, that cannot be the basis of the exam, right? And so what we've been trying to think about is how do we identify minimum competency that for all demographic subgroups, for all students, that they will be able to know what or how those skills will be assessed on the exam. So if anyone wants to follow up with the question that was actually asked, I am also happy to hear that as well.
I'll quickly follow up on that response, John, and say that um, after we have tested our grading rubrics and feel pretty confident in the fact that they're working, and that graders, including actual bar exam graders, feel confident that they're working and that they can use them and that they can agree on, what what would be a 0 response or a 1 response or a 2 response. They're coming to the same decisions on how to grade different responses. We hope to publish those rubrics so that people educating students and preparing students for the bar exam can see this is how we plan to grade those types of questions or that particular examinee task. Um, as for the original question, if I understand it correctly, I'm not sure that you know the next gen exam means that all 1L doctrinal faculty need to start teaching all of these skills or tasks. I think it opens up faculty to pick some of the tasks that they really enjoy teaching or the skills that they uh, um, they like to teach and test those. But I think as long as in the course of their legal education, they're getting uh, solid basis in all of the subject areas and a solid basis in the skills. It doesn't necessarily have to be like all the One Health faculty contributing to that. If I understood the question correctly, and just like I am not a psychometrician, I am not a law professor.
Right.
So,
Well, I would just add that the way that I see the bar examination vis-a-vis law schools is that the bar examination is a licensure exam, right? And it's to ensure minimum competency for those lawyers who are practicing so that they will effectively and ethically represent their clients. And law school is also preparing students for practice and for public policy and for all those things. But I do not believe, and this is me talking as me, that the bar examination should sort of force what law schools are teaching, right? What I see, and vice versa, right? But what I see is that through the practice analysis, as I was identifying what skills were identified as being important ones, those fit quite nicely with what we have seen in the academy when we've done similar types of studies, right? So if you look, at the Carnegie, it was all of the skills in that study were similar to the skills that we are talking about now. And yet those studies did not sort of mandate that 1L faculty teach those skills. But that said, I think it is that some faculty can see the natural connection points there, right? And then certainly in the second and third years of law school, as our students are doing more transition to practice courses, experiential learning courses, clinical courses, they will see many of these skills and practice many of these skills organically, right? And in fact, that sort of organic practice will be similar to the types of things that they will encounter on this exam as well.
Thank you. I recognize that we're running a little short on time at this point, so I want to get out there with a question for Marilyn that I think will be a really quick one, which is, will the MPRE still be an exam?
The MPRE will still be a separate exam. The MPRE we recognize as a standard on ethics exam across the country, and it will continue to be so. As John mentioned earlier, there will be ethics, parts of the model rules of professional conduct will be implicated in these integrated questions just because of the skills areas, and it would be impossible to draft these skills questions without implicating those rules. That said, this exam is not an exhaustive test of the model rules of professional conduct. That's still a necessary and separate piece. So that exam will continue.
This, I think, will also be a quick one, and I think this will go to Beth. The person asks, many students may not have the most up-to-date software due to cost. Can this exam run on older computers?
We will that have everyone has access to the right hardware that they need. We have not selected the vendor who will be providing our test engine, the software that will host the exam. So we don't have any information to share yet about that software.
And if I can just add to that, we are in the pretty late stages of working with a vendor, of determining a vendor for that purpose. So I think that decision will be coming, within months. So we're pretty far along there, and it is a priority in both test design and in the platform that we use to ensure that this exam is accessible regardless of the level of equipment available to a particular applicant. An applicant should not and will not be disadvantaged based on the level of technology that they have in order to take this exam. We're committed to that.
Thank you. I see we basically have 4 minutes left, so I am going to just note to the audience, to the group that's here with us today. First of all, thank you for being here. I'm sure I won't be the last person to thank you, but also to remind you, you're going to get a follow-up email from us after this, letting you know how questions that we couldn't get to today, how we will answer them going forward. I also wanted to let you know we had a few questions on this, that the presentation video will be posted online. I'm not sure exactly what day that will be that'll happen, but you will also get an email letting you know that this video has been the video has been posted online, so that you can rewatch if you wish, or you can share it with colleagues who weren't able to attend today. And with that, I'm going to turn it back to Marilyn.
Thank you so much. And thank all of you for joining us today to participate in this conversation and for your interest in NextGen. This is a very exciting progress for us. This next evolution of the bar exam is very exciting, and we are thrilled to have so much interest in more out there about this exam. I encourage you again to subscribe to the updates through the QR code that you'll see on your screen right now, and I will look forward to continuing discussions. This may be the first webcast of this type. It will not be the last, and we will be out there finding many ways to provide information to you and to engage you in discussions like this. So I look forward to that, and I thank you again, and I thank our speakers today.
Well, I hope you enjoyed watching that. I know it was 2 hours, but it had a lot of good information, especially if you're working for a bar prep company like me, or if you're a bar prep advisor at a law school. So thanks for hanging with me. One of the things that I thought was most interesting was the prototypes that they presented of different exam questions. Now, one of the consistent themes throughout was, hey, don't hold us to this, don't hold us to this. It's not set in stone yet what these questions are going to look like. But the multiple choice question, that was very interesting. And the way they presented the performance test like question that had a lot of short answers and it built upon itself. And they didn't say how much time it would take. They're working that out with some testing. A lot different than the traditional essays and 190-minute big block performance test. Just create one document for your supervising attorney or your hypothetical judge that you're clerking for. And so, yeah, that was really interesting. It'll be interesting to see how they can grade this. The short answer thing, I like the idea, but it does seem like it's going to make it more difficult to differentiate between students and make it easier to pass, which honestly could be a good thing. Maybe the bar exam is too hard to pass as it currently is. I don't know. That's more of a policy question, and it's something that I ponder about, but I haven't really reached a definitive conclusion. So anyway, I have some other ideas about how their questions may ultimately appear, but we'll just wait and see what they release as things come out, and we'll keep you up to date. We at Crushendo are staying in the loop as best as we possibly can, and we'll share everything that we get as best as we can on our website and here on our YouTube channel. And so whether you're a student that might be taking the bar in 2026 and you just want to be in the loop, or you're just a colleague, you're another bar prep company, we're in this together, we're all paddling in the same stream, or if you're at a law school, we're happy to help. So again, thanks to the NCBE for sharing their video with us and giving us permission to share it on our YouTube channel. We appreciate our partnership with them. We appreciate that we can access official NCBE practice questions, and we license those and we use those with our students. We know those are great practice questions, and so we value that relationship with them. And that's all for us today. Thanks so much for watching. God bless and stay awesome.
Crushенdo's revolutionizing legal education with hundreds of mnemonics and illustrations, thousands of practice questions, affordable pricing, lifetime access, whiteboard videos, plus audio outlines and audio flashcards. Master the law faster and with more freedom than ever before with Crushendo. You should definitely check out crushendo.com today.